Good afternoon, everybody. Thank you for joining us for the Family First Prevention Services Act placement process changes. And thank you for your patience as we are working out some technical difficulties right now in this, our first of our series of FFPSA webinars. These webinars are going to be presented by the Child Safety and Permanency Division and will be covering a wide variety of topics pertaining to the Family First implementation. So my name is Ashley Solsrud-Beckman, and I am going to be leading us off here today. Let me see how here we go. So some housekeeping. First of all, so you understand, today's webinar is going to be recorded, and we will be posting it through the Child Welfare Training Academy in a few days following the presentation. So please keep yourself on mute and sign into your chat with your name and facility, or name and county that you are representing. At the end of the webinar, we will be going through questions, but please feel free to post questions in the chat or using the Q&A as we go forward, as they come to mind. We will be monitoring the chat and gathering those questions, and we'll be saving some time at the end in order to review. Today's presenters from Safety and Permanency include myself, Ashley Solsrud-Beckman. I am with a Child Foster Care Wellbeing Program Representative. Deborah Beske Brown, she is the Foster Care Unit Supervisor. Sarah Ladd, Human Trafficking Child Protection Program Coordinator. Tamara Moore, Expecting and Parenting Youth Specialist. Amber Buckner, Title IV-E Foster Care Consultant. And Nicolas Vogel, Extended Foster Care Policy Specialist. And then Eric Kratt, who has also already spoken to you guys a little bit, will also be talking to us a little bit about some SSIS changes. And with that, I'm going to pass the torch over to Deborah Beske Brown, and she's going to get us started with today's presentation.
Thank you, Ashley. And thank you everyone for joining us this afternoon. Today's webinar is an invitation and an opportunity to learn about the purpose of FFPSA and the impact it will have on child welfare. We'll also talk about how you may be able to use these changes to improve placement for the children you work with. I will also mention that that will be not only our theme today, but the theme throughout this webinar series. Throughout the last 2+ years, the department has been partnering with residential facilities, child welfare agencies, including Ffpsa, tribes, and community partners across the state to create this new process and make plans for implementation. I'm happy that you can join us today. I'm assuming that you will learn many things today and many things as we go through this webinar, and will rise in many questions. So be sure to use the chat to bring up those questions as we go forward. So let's move to the next slide. This slide is just an introductory of what Family First Prevention Services Act is. And it has many components to it, but the two major components is about the Title IV-E prevention services and the state creating a plan for those prevention services to prevent foster care placement. And the other major component is that it strictly limits federal reimbursement for children's placement in group residential settings by establishing very specific criteria and rigorous requirements. In Minnesota, these modifications will take effect on September 30th, 21, which is merely a month and a half away, a month and 3/4 away. Next slide, please. Primarily, the Act's purpose is to change Title 4E in order to enable states to use Title 4E funding to broaden services to prevent out-of-home placement, encourage the use of family foster homes as the primary out-of-home placement plan solution, and to limit the use of group residential care, congregate care settings are often called, by increasing the requirements for placing processes and the types of facilities that are Title 4E eligible. Next slide. Today, our objective of this training is to provide an overview of placement policies and practices that will be modified by the implementation of Ffpsa. We are not going to go into great detail today, but rather provide a general overview of them. Each session that follows this will provide much more detail about each component of these of the implementation of Ffpsa for residential placements. So I just want to make sure everyone knows that we're not covering every piece today, but that we're providing an overview of them. The training will introduce the changes and modifications, and we'll go into more detail in the next month and two, 2 months roughly. Next slide. This is our agenda. I will just hit the high notes here. We're going to talk about what Ffpsa is. We're going to talk about the impact, and we're going to talk about next steps. Next slide. Next slide. One of the things I wanted to just open this up with is a clarification about what foster care placement is. For many, this is a very clear component, very clear idea, but for some, we get questions often about, is this a foster care placement? So just to provide the general definition of what child foster care is, that the Title 4E agency has decided that a child is placed in any setting away from their parent, and the county or tribal agency has placement authority. And that authority may be a court order or a voluntary placement. The child has to be placed away from their parent, but there are exceptions to that rule, such as a trial home visit or when the child is co-located with their parent in a substance abuse treatment program. Next slide. Oh, one of the other pieces, I guess, I'm sorry, with the previous slide I wanted to mention, is that it does not matter who's paying for the placement. We often get that question that if the county or tribal agency is not paying for the placement, is that foster care? And that is not a determining factor for what foster care is. These two are the primary determining factors. Thank you, I'm sorry, then we can go on. For foster care placements after September 30th, Ffpsa requirements will apply to all group residential settings. And that includes this list that is on the screen. Placements prior to September 30th, meaning September 29th, will be considered legacy, and the provisions of Ffpsa will not apply to those placements, except if that child moves from, say, one group residential setting to a foster residence setting, which we call a corporate foster home. That corporate foster home would then, the application would then apply. Ffpsa would apply to that placement. So the child has to be remain in the same placement for it not to apply. If the child moves from one residential placement to another, or from a foster home to a residential placement, Ffpsa provisions would apply. Going on. Foster residence setting. This is an area that is, I think, a major change. We have considered what we often term as corporate foster care or waiver foster homes as being similar to family foster homes in the past, where we do a Ffpsa for that placement, and they are considered a family foster home, meaning that they are eligible for Title IV-E without any action by the agency or the county to make that facility Title IV-E eligible. With the implementation of Ffpsa, that changes. Ffpsa limits the definition of family foster home to the home of an individual or family where the foster parent resides in the home with the child. And that is not the definition of what a foster residence or a corporate foster home is. A foster family home may not include licensed group homes as previously permitted if the facility is not the home of an individual family. Due to these changes, corporate foster homes will be considered child care institutions for foster care placements for the purpose of placement, not for the purpose of licensing. Nothing on the screen talks about any changes in the licensing process in Minnesota for these facilities, but it does talk about how they will be viewed for placement purposes. I will also add that payment, I guess that's the next slide. The payment also changes because of this. The Ffpsa can no longer be used to apply to placements for new placements after September 30th, because these are no longer considered child foster homes, and therefore they're no longer part of North Star Care. And we need to determine their payment differently as we do other residential facilities. The department will approve foster residence settings for Title IV reimbursement, and Amber will talk about that in a minute. I also just want to mention that there is legislation that has passed, and you will see that in our legislative bulletin that's coming up that will be released shortly, that talks about for our foster residence setting, it is not required to have a host county or lead county contract as it is required for other residential facilities. Rather, they will be paid a straight rate based on the basic rate as determined by North Star Care. So while I said that North Star Care no longer applies, the basic rate will apply to these facility placements. And that would be what is used to determine the daily board and room payment when children are placed in these settings. Going on. So these are the new certifications for residential facilities and foster residence settings or corporate foster homes under Ffpsa. The first one listed is the Qualified Residential Treatment Program, or what we commonly refer to, and you'll hear me say this a lot, the Qrtp. I will talk about those programs later, but know that that is probably the more complicated area of the what's required for placement in those settings. The others are specialized settings, and there will be certifications for these as well, and we will have presenters on each one of these specialized settings. But the first one is for pregnant and parenting youth, and Tamara will talk about that. The next is settings for youth who have been or at risk of sex trafficking or commercial sexual exploitation, and Sarah Ladd will talk about that. And the final one is the supervised independent living settings in facilities for youth 18 to 21. And Nick will talk about that, Nick Vogel. Going on. So one of the other areas that's impacted, and you will also notice that there's a training planned on AFGARS. And AFGARS is the Adoption and Foster Care Analysis and Reporting System that is set up by the federal government. And they have very strict requirements to how we report data regarding out-of-home placement, children who exit out-of-home placement, to adoption and legal guardianship. There's been a new rule that was effective July 13th that incorporates many of the provisions of Ffpsa in that new rule. Therefore, there is significant changes that have occurred in relationship to when you're entering a continuous placement, how that continuous placement is entered, what those settings are considered, and how, and I believe we're also going to talk a little bit about exiting foster care. I just want to point out that that webinar is coming, and if you're responsible for entering continuous placements or changing continuous placements, then I would strongly suggest that you attend the AFGAR's webinar later this month. And I believe it's August 31st, as on the bottom of the screen. Next slide. So warning, big changes are ahead. Implementing Ffpsa requirements will be a phased-in process, as I've already explained. It will only apply to those children who are placed in residential facilities on September 30th and after. It does not apply to any child who's currently placed in a facility or children who are placed before September 30th. They will remain legacy as long as nothing changes with their placements. And as you consider plans for children, you may want to take that into consideration about who will be moving into those placements or what your plans are to alert some families that you're working with that things might be changing very soon. I believe I am now passing, yes, I am passing this on now to Amber Buckner, and Amber is going to be talking about Title 4A claiming.
Thanks, Deb. Can everyone hear me?
Yeah, we hear you.
Okay, great, thanks. I'm Amber Buckner, Title 4E foster care consultant here at DHS. And Ffpsa defines the Title 4E eligible settings as there are the PPY, which is the program setting for pregnant and parenting youth, which provides prenatal postpartum care. Then there is the program for youth who have been or at risk for sexual trafficking or commercial sexual exploitation, STY. And then there is the supervised independent living services for youth 18 to 21. And that is the SILS. And then there's the Qualified Residential Treatment Program, QRTP. And the important thing here is that the foster care payments are limited to the first 14 days after starting October 1st, unless they are in one of these settings. Next slide, please. And the legislation this session created the certification standards in Chapter 245A for Qualified Residential Treatment Programs, QRTP, Pregnant and Parenting Youth Programs, PPY, the programs for youth who have been or are at risk for sex trafficking or commercial sexual exploitation, STY, and supervised living settings for youth that are 18 to 21, SILS. Certification standards are in addition to existing license requirements for children's residential facilities and foster care residence settings. Next slide, please. DHS Licensing will issue certifications and review the requirements for programs and facilities licensed by DHS and DOC, counties and private licensing agencies, which includes foster residence settings. Applications for the new FFPSA certifications became available on June 30th, 2021. Programs and facilities can choose whether or not to seek these certifications. And programs and facilities may have multiple certifications if the design of the program and or facility are appropriate. Next slide, please. So for Title IV-E claiming, the programs and facilities currently eligible for Title IV-E reimbursement will need to become certified for one or more of the 4 new setting categories listed in this bulletin. When the programs and facilities have received the certification, the licensing division will notify Title IV-E staff, and no additional information will be needed for the programs and facilities to remain Title IV-E eligible. For the programs and facilities that are not currently Title IV-E eligible, the programs and facilities are required to obtain certification from Dhs Licensing for one or more of the specialized settings, and the county submits the documents on behalf of the programmer and facility to Dhs Licensing, or excuse me, to Dhs Financial Operations Division, and the email address and the forms are on the next slide. Next slide, please. So the counties and tribes should send the forms to the email address listed for the Financial Operations Division. And the forms that they need to send are the notice of contracted per diem rates and the Title IV-E checklist. They need to also send a copy of the license for the facility or the program, a description of the programs and services. So all those go into the email right there for financial operations. And an expedited process is in place for those programs and facilities that are currently approved for Title IV-E that have already been certified by one of the, accredited by one of the national accrediting agencies. Next slide, please. So how you will obtain Title IV-E approval for your program or facility is when the facility meets the requirements of FFPSA settings and has a lead county contract in place, the placing agency may apply for the facility's Title IV-E approval. The Financial Operations Division will provide information about how the Title IV-E foster care per diem rates and percentages report will be modified to provide information about the Title IV-E approved foster residence setting. And that the per diem list can be found at this link right here on County Link. And that's exactly how to get to that report, but the settings are not listed on that report yet, but they will be as the facilities are certified for the settings. And the Lee County contract down here, there's a note. It's not applicable for the foster residence settings. Next slide, please.
All right, so now we're going to talk a little bit about placement decisions and these new FFPSA settings. So these are some basic things that we will need to consider in order to consider one of these residential placements. So obviously we'll need placement authority. There needs to be a court order or a voluntary placement agreement. And as always, the preference is for kids and youth to be in a family foster home or to be placed in kinship care. And then another thing to consider is that the best interest factors will still apply. And FFPSA does not change any ICWA or MIFPA requirements. And as was mentioned before, children may have needs that fit into one or more setting type. For example, there may be a young person that is parenting that also has some mental health concerns. And so just figuring out which type of placement is best suited for that young person. And another thing to consider is that there are additional requirements prior to placement in a QRTP. And those are, there will need to be an assessment. There will need to be a juvenile treatment and screening team. And then there will also need to be a family and permanency team. And we'll talk more about that. And then there will also be separate webinars about those topics as well. So due to these new requirements, case managers will need to be aware of which facilities and which license they have and what certifications they have prior to placement. And the best way to figure this out is to look on the licensing lookup website. And so here on the next couple of slides, we just have the links and a screenshot of what the licensing lookup looks like. And then eventually these new categories, these 4 categories that we're talking about today, will be added to the residential services types. So you will look this up for children's residential facilities and those and the other facilities, which we would typically call corporate foster homes, those foster residence settings. All right, so these are the 4 placement settings. We've seen this slide. We know that these are the settings. And so just a quick snapshot of those there. And so we'll begin talking about the specialized settings first, and then we'll go into the QRTP at the end. So as was mentioned, I am Tamara Moore, and I am the specialist for pregnant and parenting youth in foster care. And so we'll just talk a little bit about some changes in that area. And before we get into the pieces about the residential care, I just want to draw your attention to the new expected and parenting youth screen in SSIS. If you can switch the slide, that would be great. So there's a new expected and parenting youth status screen. And so as of September of 2020, this screen has been required if there's a continuous placement with a start date on or after 9/1/2020, and if the young person is 10 years old or older. And so we have been documenting the youth that are pregnant and those that may be parenting. So both male and females that may be parenting. And an EPY screen with a last review date in the last 6 months is required for all youth in care, no matter what the setting is. So this is something just in general for all foster youth in care. And so we have been collecting this data, and now we're going to be adding another data element. And so we will begin to document expecting fathers too. And that data element will be released in the next SSIS release on September 15th. So we'll be documenting pregnant youth, expecting fathers, parenting mothers, and parenting fathers for all youth in care that have a continuous placement and that are 10 years old or older. And so what that will mean is if it doesn't apply to that young person, then you just click no, doesn't apply on that particular screen, and then you're all set to go. The next slide will go into a little bit more about the residential placement for pregnant and parenting youth. I'm really excited about this type of setting because it allows for youth and their children to be co-located together. This setting just allows for that to happen. And so when we're talking about the eligible population, we're talking about pregnant youth, so females, and not expecting fathers. I know on the previous screen, we said that we're documenting those expecting fathers. We are still documenting them, but they're not eligible for this particular placement setting. So the eligible populations, pregnant youth and parenting mothers and or fathers. And then the programs will offer prenatal and postpartum support and parenting support and education. The next slide will take a look at the placement considerations. This is kind of a 5-step process. Of course, there's going to be other steps in between, but these are the basics. So you want to assess the need on the best interest of the youth and their children, and decide if their needs can be met in their home or if out-of-home placement is even necessary. So remember, the spirit of Family First is to keep kids in their home, and then to limit the placement in residential care. And also, of course, there would need to be placement authority. And then this is just a reminder that youth must not be placed in foster care solely due to being pregnant or parenting. So just keep that in mind. And then we would want to determine if the youth and their children's needs can be met in a family foster home setting. So that would be the preference over putting them in a residential placement. If it is in fact determined that this residential placement is best, then you make the referral to the PPY residential setting. And then just a reminder that this must be documented in SSIS on the EPY screen. Otherwise, the placements won't connect and there'll be issues with payment and such. So this screen is critical. So with the next slide, we'll just talk about a little bit about what the residential program requirements are. And these requirements are laid out in 245A as well. So in order for a facility to be certified for this setting, they must offer these services at a minimum. So they have to provide prenatal and postpartum and parenting support. And they also have to assist with accessing sexual and reproductive health services and education, as well as postpartum mental health assessments and follow-up services. So that may look different for different youth, but they have to help the youth navigate those services. Additionally, the programs have to provide education on safe bathing and reducing the risk of sudden unexpected infant death. So we would usually sometimes call that SILS. And then also they need to provide education on abusive head trauma from shaking, also known as shaken baby. So these are just some basic requirements for a facility that will serve this population. And there will be more details about these elements in the next training that will focus on expected and parenting youth. The next slide, please. So the next, the in-depth conversation or webinar on expected and parenting youth in foster care will be at the end of September. And just as you register for this webinar, you can register for that one as well. And then in the meantime, if you have any particular questions, you can feel free to contact me directly. And now I'm gonna hand it over to Sarah Ladd, who will talk about the next specialized setting.
All right, good afternoon, everyone. I am so glad to be here with you all today. My name is Sarah Ladd, and I am the Human Trafficking Child Protection Program Coordinator at DHS, and I'm going to talk with you about settings, specialized settings for youth who have been or are at risk of sex trafficking or commercial sexual exploitation. So I'm going to give you the quick overview of some of the most critical things that are going to change and how you might, particularly those of you who work within the child welfare system, how you might interact with and utilize these settings for the youth in your care. Next slide, please. Okay, so I want to start out here with what I think is a really important foundational element to understanding how you will interact with these settings. And that is just by helping everyone to either remember, recall, or to learn for the first time that trafficking, sex trafficking, commercial sexual exploitation both happen all across our state, in small communities, in large communities. We also find youth who are at risk of sex trafficking or commercial sexual exploitation in every community in the state of Minnesota. So we have found that. I want to share two different ways that that has been demonstrated to us. One, since we began our required child protection response to sex trafficking in May of 2017, we have had more than 1,600 reports of minors experiencing sex trafficking or sexual exploitation in Minnesota. We have received reports in all but 5 child welfare agencies. So it is virtually everywhere within our state. And so we know that this is something that occurs and that youth are facing the victimization and abuse of sexual exploitation and sex trafficking. Now, in addition to that, the Minnesota Student Survey had a question added to it, and we collected the results in 2020 that demonstrated that at least 5,000 young people in Minnesota have experienced, they have self-identified anonymously as experiencing commercial sexual exploitation and sex trafficking. At least 5,000. And I put this up on the screen just briefly to try and quickly kind of demystify some of what trafficking is. Often we think of trafficking as only happening to females. And we have learned through this data from the MSS survey and also through the child protection reports that have come in over the last 5 years that trafficking absolutely happens to cisgender boys and cisgender girls. And it happens at almost equal rates in Minnesota. It also happens at even higher rates to transgender youth and to youth who identify themselves as being unsure about their gender identity. In addition, there are racial disparities when it comes to trafficking. And we see that varying a lot across our state. But so I want to just make this really clear, because as we have begun this conversation about Family First and about how to identify youth who would be eligible to be placed in specialized settings for sex trafficked, sexually exploited, or at-risk youth, there have been a lot of questions about, well, is this girls and boys? And is that, and who are we trying to identify? And so please keep this important information at the front of your mind as you begin to try and identify youth who may be experiencing trafficking or exploitation or who may be at risk. Next slide, please. Okay, so why a specialized setting for sex trafficked, commercially sexually exploited, or at-risk youth? So I will talk in a moment about what these definitions are and who would qualify to be in them. But first, why do we even need a specialized setting for this population? So there are some core elements, some core things that we have found here in Minnesota and across the country in some of the research that's been done and some of the questions that have been asked of survivors, that there are some core things that really mean that we need a more specialized placement for some trafficked and exploited or at-risk youth. So one, there are different safety needs, both physical and emotional safety needs. And some of the certification requirements, I do want to say, which Tamara mentioned and Amber has mentioned earlier as well, do kind of mirror this list. But so safety is a critical component. Staff that are highly trained to work with youth and identify youth who have experienced trafficking or exploitation or who are at risk. Also, access to more specialized services, including the ability to partner with our Safe Harbor network of providers and to provide access to mentoring and other support from staff or from community-based providers who are people with lived experience, who are subject matter experts in trafficking because they have survived it. A higher level of collaboration and communication, and then finally, access to human trafficking prevention education. Those are the core components and the reasons why a youth may need a specialized setting, or if they are a trafficked, exploited, or at-risk youth. So which youth are trafficked, exploited, or at risk? So we have a bulletin that we have published that is linked on the same website where you registered. And it puts all of these definitions into a lot more detail for you. But just briefly, there are 3 different definitions through which you could identify youth who may be eligible to be placed in one of these specialized settings and get the Title IV reimbursement. So first, youth who have been sex trafficked, meaning that they meet the Minnesota, they are identified by a child welfare staff as currently or previously experiencing sex trafficking, which involves a third party. They also may be identified by someone within child welfare as having experienced in the past or currently commercial sexual exploitation, which is any type of commercial sexual activity, whether or not a third party has been involved in the exploitation. Then also, youth who are identified as at risk for sex trafficking or commercial sexual exploitation may be eligible to be placed in these types of settings. So there is a very a kind of lengthy and detailed definition that we have created after a lot of research and engagement with stakeholders and many of you across the state that really breaks down this definition into primary risk factors, secondary risk factors, and kind of has different scoring. So if a youth, for example, has any one of the primary risk factors, meaning that they are experiencing another type of exploitation or trafficking already, or they have in the past, or they are associated or closely connected with people who are experiencing exploitation or trafficking. For example, those are 2 of the primary risk factors that without meeting any of the other factors, that would make them eligible to be placed in a specialized setting as a youth who is at risk for trafficking or exploitation. Then there is a longer list of 9 additional secondary risk factors that are quite honestly pervasive within the population of youth who are in the care of the child welfare system. For these factors, such as current experience of abuse or trauma, homelessness, drug use, family conflict, gang affiliation, and more. These kinds of factors, we would ask that a youth have at least 2 of them in order to meet this definition of at risk. Next slide, please. So, oops, that doesn't look like the right slide. Let's go on to the next one. Or we can go back to Tamara. Oh, okay, there we go. All right, sorry about that technical difficulty. So these specialized programs, so I told you a little bit about the youth eligibility. Now, what will these programs actually provide? I want to start this brief part of our conversation with a quote from our Voices of Safe Harbor report that was published at close to the beginning of our Safe Harbor response here in Minnesota. And a youth who had experienced trafficking explained what they need in a placement setting. And this is what this youth said: a place with people in similar situations, where people won't judge you by what has happened to you or by your race or religion, or also a place where you know someone dangerous won't come in. Control is kind of comforting. A program where they let you decide for yourself, let you grow on your own. So there are a few things to consider here when thinking about placing a youth in a specialized residential program to serve this population. So first, programs who apply to be certified and who get approved through Title IV-E may decide to serve either sex trafficked and sexually exploited youth, or youth at risk of trafficking and exploitation, or both. Okay, so pay really close attention to that part of kind of figuring out which programs might be a good fit, because depending on the program, they may set up their service delivery model, and they may serve all populations, right? Trafficked and exploited youth and also at-risk youth, but they may have them together all the time. They may have them separated sometimes. So that is going to be something to really understand when you are making a placement. Second, there will be many different types of programming and many different service delivery models. So this is one of the things that is the most exciting as someone in my position, where I get to work with all of you across the state, and I get to work with our whole network of Safe Harbor grantees and many of our law enforcement partners and county attorneys, and I get to hear what all the needs are. It is so exciting that we have residential programs of so many different types who are seeking this certification. Very small group homes that provide really intensive therapeutic services. We also have shelter programs who are seeking this type of certification. We also have programs that serve very young children or that serve sibling sets who are seeking this certification. And we have more intensive mental health treatment centers who are seeking this certification. And I know I probably just messed up all the titles of all those different types of programs, but hopefully you understand that there are many different models, and that has the potential to fill a huge gap for youth who experience trafficking and exploitation in our state today, because they have not always had all of those options. So finally, the last consideration here, and I am almost done, I'm so over time. So this is really important to remember, and I will show you a slide briefly about our Safe Harbor network in just a moment here. But really important to remember that there are funded Safe Harbor shelter and housing programs across the state, and those programs still will be funded by Safe Harbor. There will be some of them, we believe, who will seek this certification, licensed programs that serve minors that will seek this certification and will try to become approved for Title IV-E under this certification. There are others that may not, but they still would accept self-referrals of sexually exploited youth as Safe Harbor programs. So I just want to mention that we do have this network of specialized housing and shelter programs that exist currently around our state and that will continue to exist even after September 30th. Next slide, please. Okay, so quick note on this. So how are youth placed in this specialized setting? First, they have to be identified. And similar to what Tamara said regarding expectant and parenting youth, it is currently required that all youth who are in any work group, for any child-related purpose, must be screened and identified to see whether they have experienced sex trafficking or commercial sexual exploitation. So we are asking that when youth are going into placement and you're making those determinations and finding that there may not be an appropriate, that it is necessary to place them, that there may not be an appropriate kinship care placement or family foster home, and they may need residential care in a congregate setting, we ask that all children and youth be screened and identified if they are trafficked, exploited, or at risk, and they are in placement, and they are, and you are seeking a congregate setting for them. So that will be documented in SSIS. I know everyone loves the SEY screen, now called the SEY-STY screen, soon to be called SEY-STY and at risk, because yes, friends, that's where it's going to be documented. So that will be an important requirement. Again, as Tamara mentioned, connected to reimbursement and payment, connected to the placement screens. So that will have to be, they'll have to be identified most importantly so that you can provide excellent services to them, but they also will need to be, that will need to be documented. Okay, next slide, please. And I'm almost done. I have just a couple final thoughts here, just to say that we do have a best practice guide regarding the child welfare system response to trafficking and exploitation of children and youth in our state. And that best practice guide will be updated very soon to include a lot more detailed guidance about this family first implementation in terms of trafficked, exploited, and at-risk youth. Next slide, please. And don't forget your partners. So we are so fortunate here in the state of Minnesota that we have a phenomenal statewide safe harbor response. If you do not know your regional navigator in your region, there are 9 regional navigators across our state. I highly encourage you to get connected, reach out to your regional navigator. If you go to our DHS Safe Harbor website, you can get linked right over to the Department of Health, and you can find out who your regional navigator is. Residential facilities are also strongly encouraged to get connected with their local regional navigator and also service providers in their area. So please, please, don't forget to make those connections and also provide those services, whether it's discharge or whether it's earlier on in working with a child and family. Also, if you're interested in learning more, please feel free to email me. My email address is on this slide as well. And one last slide, if you can advance one more time for me, Ashley. Okay, so what's next? A couple of training pieces. Now, I decided to just sneak this in here. A relatively large change happened. This will be explained in our legislative update bulletin coming out, and we will be providing more guidance on this soon in partnership with the Minnesota Child Welfare Training Academy. But there is a new child protection training requirement to enable all child protection staff statewide to be able to identify youth who have experienced trafficking or exploitation or who are at risk of trafficking and exploitation. So effective August 1st, all staff with child protective duties under 260C or 260E must take an approved training on identifying and responding to trafficking. So more information coming on that. Those of you who've already been trained in new worker training and taken that module on trafficking and exploitation are covered. Anyone who has taken our Child Welfare Training Academy 2-day training on working with trafficked and exploited youth are also covered. We will be publishing later on soon in the next several months a shorter training that can be taken as a standalone to fulfill this requirement and to get ready to be able to really work with these youth and identify them. Then finally, if you want to learn more and spend more time with me, please come on September 14th from 1 to 3. We are going to have a webinar with a panel of folks who have been involved in developing these specialized settings, and most importantly, we will also be hearing from survivor subject matter experts about why these settings are important. That webinar is happening September 14th, and I hope that you will join us. So thank you very much. I'm going to pass things off to Nick, who has promised a very short presentation. Thanks, everyone.
Thank you, Sarah. You can skip to the next slide already. So I'm going to touch base a little bit on the 18 to 21-year-old population. And as Sarah mentioned, really what we're trying to do is fill a gap here. There's a lot of placements where you all have tried to get placements for young adults, but you maybe think that maybe they're not quite ready to live exactly on their own in their own apartments and things like that. And so what this is it's a setting that's going to be licensed. So it's going to be a facility setting, and it is for young people that are in extended foster care, meaning that they have to be between the ages of 18 and up to 21. They also have to continue to meet criteria, keeping in mind that the criteria can include something like a facility like this could be considered an activity or a program designed to remove barriers to employment. So something to keep in mind, if your young people are not meeting criteria, they could meet criteria in a setting like this. The big part of these specialized settings is that they are going to be required to offer training, counseling, things like that to get our young adults ready to live on their own and live independently on their own. So they are going to be required to offer those types of services in their setting. Next slide. The big thing that we want to remember here is that this is not to be confused with our what we currently call supervised independent living. Currently, what we call supervised independent living are settings that are not licensed. Our young people typically live there on their own. And typically in those situations, our young people are receiving the payment themselves. And so we don't want to be confused that these facility settings, the facilities will be the ones receiving the payment, not to be confused with currently what we call supervised independent living, where our young people are living independently, completely on their own. And typically these are settings normally like a dorm or an apartment or a host home, things like that. And so we don't want to confuse these two settings. Next slide. So if you think I'm cool and you want to hang out a little bit more with me, I'm doing a webinar from 1 to 2 o'clock on Tuesday, September 28th. We're going to just go into depth a little bit more on what we touched on today and kind of offer some of the facilities that we think may potentially be a good setting for this. Next slide. So in talking about all the facilities that we talked about today, including Tamara's, Sarah's, and then the supervised independent living setting, we just want to remind people that these three types of facilities must be certified by licensing, and that the certification standards are adopted in 245A, and they also must obtain Title IV-E approval. And so that's all I have for you today. I'm going to turn this over to Deb Beske Brown, and she is going to cover the QRTPs.
Thank you, Nick. Thank you very much. I also want to repeat what Nick just said, and I think it's a really important piece. The QRTP type of facility has gotten a lot of discussion, and we tend to talk about the QRTP facilities, but all the specialized settings that you have just heard are Title IV-E eligible, as well as the QRTP. So not all settings need to be, or all residential facilities need to be QRTPs to be Title IV-E eligible. They can be any one of the specialized settings you just heard about. And to make sure that everyone understands that, because I think it gets very confusing, and most of our focus has been on the QRTP because of its very detailed admission process. So with that, I'm going to move on to the next slides, which is about the QRTP and the detailed admission status. So what is a QRTP? The certification that was developed in 245A for a QRTP includes all of these elements. They need to have a trauma-informed treatment model. Previously, we've been talking about trauma-informed care with the specialized facilities. This is different, where it actually requires a trauma-informed treatment model. They need to have a registered or licensed nurse and other clinicians available 24/7 and on site according to the program's treatment model. That does not mean they have to be on site 24/7, but the treatment model must define when they are on site. Facilitates family members' participation in outreach, including siblings. Documents how family members are integrated into the child's treatment process. Provides discharge planning and aftercare supports for 6 months, and is licensed according to the Title 40 requirements and accreditation. And keep in mind that is an accreditation from one of the recognized accreditation agencies. Going on. The process for a QRTP placement. For a child to receive services for emotional disturbance, developmental disability, or related condition in a QRTP, it starts with the County Social Service Agency's Juvenile Treatment Screening Team. And this is in reference to county agencies who have this process. Tribal agencies may have a similar process, but the county conducts a screening and recommends that placement in a QRTP. Next week, we are going to have a training specifically about the Juvenile Treatment Screening Team. But the county or the tribe is the first point of decision-making, just like it always has been. The child may be placed on a QRTP placement on an emergency basis and bypass the Juvenile Treatment Screening Team. I also want to mention that it is not required for the other specialized settings we've just talked about. You do not need to have a screening team meeting for a residential placement in one of the other specialized settings, such as pregnant and parenting youth or sex trafficked. But you may, if the agency decides they want to and makes that their practice, but it's not required. Going on. This is a screen you may have seen before. And I just want to pay a little attention to the process of the QRTP placement process. I will note that the far end arrow talks about the child entering a QRTP. Federal reimbursement ends, or federal participation in the placement cost ends after 14 days, unless the following conditions are met. Now, this is true of other residential facilities also, that a residential facility may not meet any of the specialized settings or QRTP, but may be eligible for 14 days of federal participation. Where that may be helpful is when you have a child placed in a shelter facility. Going on. So in the first 30 days after placement, there needs to be an assessment by a qualified individual. That assessment may occur prior to, and you'll actually see slides later that actually say it's preferred that the child have the QRTP placement or assessment prior to placement. After the assessment is completed, within 60 days of placement, there needs to be a court review of the assessment completed by the qualified individual and of the QRTP placement decision. If the child continues in care at that QRTP or moves from one QRTP to another, there has to be an approval process if the child is 13 or younger and remains in that placement for longer than 6 months. If the child is older than 13, that same assessment occurs if the child remains in a QRTP level setting for 12 months or longer. Discharge planning is required in a QRTP. And aftercare, family-based services, is also a requirement after the child leaves the QRTP. And that has to be provided by the residential placement, that residential facility that provided placement. There will be more detail about what the aftercare program looks like and the aftercare requirements later after implementation. One of the pieces you'll hear us talk about in a little bit is a family and permanency team and their role in the assessment. And that the court must review their decision about the placement at every court hearing. So going on. The assessment to determine the appropriateness of a QRT placement must occur prior to or within 30 days. As I said, there is a preference in Minnesota statute that requires that says the preferences of the placement occur prior to. The qualified individual is the person who conducts the assessment, and that the responsible county or tribal agency would refer that child and their family and permanency team to a qualified individual. A qualified individual is a trained professional or licensed clinician who is not an employee of the agency or connected to a placement setting. We will be having training available for designated qualified individuals through the Child Welfare Training Academy. Those trainings will start to be available next month. The assessment is done in conjunction with the family and permanency team, which is assembled by the county or tribal social service agency, and that information is provided to the qualified individual. Next slide. What is the role of the qualified individual? They must assess the child's strengths and needs using an evidence-based functional assessment. We have determined to use the CANS as the Minnesota Functional-Based Assessment, and that will be part of the training that's provided to qualified individuals. They will be certified on the CANS that we've developed, the QRTP CANS that we've developed for this purpose. They need to determine whether the child's needs can be met with family members, meaning with their home, with their parents, or placement in a foster home. If not, if they can't be met, if the community, the family, or a foster home cannot meet the child's needs, which setting provides the most appropriate level of care in the least restrictive setting, consistent with the child's permanency goal. So the other piece of information that will need to be provided to the qualified individual is, what is the child's permanency goal? And with a voluntary placement agreement, that's typically reunification. The qualified individual also develops a list of the long and short-term needs of the child mental health goals based on the CANS. Going on. The qualified individual determines the reasons why the child's needs cannot be met in a family or foster home. And this is federal language. What I'm about to say is a shortage of family foster homes is not an acceptable reason. Why the recommended placement in a QRTP is a setting that provides the child the least restrictive setting, and how placement is consistent with the long and short-term goals for the child as specified in the permanency plan. Going on. Case plan requirements. You will also note that there is a webinar coming up on the out-of-home placement plan. And there's been some significant changes made in the out-of-home placement plan, many of which I'm hoping you will see as upgrades that will improve the functionality of the plan, as well as to incorporate the Ffpsa elements into the case plan. I'm going to just note a couple of pieces on here and not read the entire screen to you, but I'm going to note that the who is involved and not involved in the family and permanency team is listed on the out-of-home placement plan. So we must provide that information to anyone who has access to the out-of-home placement plan, which will include the court. If reunification is the goal, evidence that the parent had input into the membership of the team, there's actually quite significant policy related to the role of the parent with the agency and the role of the child with the agency in developing the membership of the Family and Permanency Team, and you'll hear more about that at the Family and Permanency Team training. Going on. It also requires the agency to list the reasons why the child's needs cannot be met in the family or the foster home. That would be taken from the qualified individual's assessment. Why the recommended placement in the QRTP is a setting that will be the least restrictive, and how the placement is consistent with the child's permanency goals. Going on. The plan also must talk about the evidence that the QRTP assessment was done in conjunction with the Family and Permanency Team, what the placement preference of the Family and Permanency Team members were, recognizing that a child should be placed with their siblings unless the court finds that placement is contrary to the child's best interest. If the placement preferences of the team and the child are not the setting recommended by the qualified individual, what is the reason? And then finally, noting the outcome of the court hearing, whether the court approved or disapproved of the QRTP placement. Going on. The 60-day court hearing, and this can happen in state or tribal court, must review the qualified individual's report when the qualified individual has approved the QRTP placement. It reviews the items that are listed on the screen, and they must provide a court order that either approves or disapproves the placement. This is not required to be in what I would consider a court appearance by the agency or the family, similar to the 260D case reviews that happen in 165 days. This can be an administrative review that happens. The process is for the agency to turn in a report, and then that report is reviewed by the court. An appearance can be requested by any of the parties. More information will be provided by this at our webinar that's coming up about this. We have also worked with CJI, and they are doing trainings for judges, and we're also doing trainings with county attorneys with information about this court review process. Going on. After the extended placement in the QRTP, the placing agency must certify that the placement continues to be the most effective and appropriate level of care for the child. More work will be done on this. This is the area that you will hear more about in early 22 for a child under 13 who is placed in a QRTP in October. The earliest this would be happening is April of 22. So we will be providing more information about this in late midwinter. Going on. Oh, I'm turning this over now to, that was my last slide, and I'm turning it over to Ashley, I believe. So Ashley, can you recap for us?
Hey, everyone. All right, so I know that was a lot of information to take in. But we really want you to understand that there's going to be a learning curve for this implementation. We're still learning how this is going to work, and you guys are also learning how this is going to work. And with that, we've come up with some ideas of next steps that you can do to help your agencies prepare for implementation. So these are just some questions that we thought would be helpful for you to consider as you prepare for Ffpsa implementation. So first, what are the needs of the community you serve? Consider demographics and their needs. Sarah and Tamara both told us extensively about the pregnant and parenting youth and sexually trafficked and commercially exploited youth. How are those demographics represented in your community? And then what sort of treatment programs for youth are available to you right now? Do you have many youth in your agency that need treatment programs? Do you have many youth in your agency that are in extended foster care or could benefit from being in extended foster care? How are you reaching out to your partners to determine how to best serve children? So when we're talking about partners, we're talking about your partners all across the child welfare spectrum, reaching out to your children's mental health partners, reaching out to your disability services partners, your court partners. What coordination may be needed to comply with congregate care placing requirements? Are you going to need to have some interagency agreements perhaps with your neighboring counties? Will you need to engage in multidisciplinary coordination across child welfare, disability services, and children's mental health? Do you have this type of coordination in place already? What can you do to strengthen that coordination? We will be having a webinar in coming weeks about qualified individuals, and training has already been underway to train the trainer for qualified individuals, but we know that we're going to need more of them. Do you know people who would make good qualified individuals? And then finally, we're going to share at the end here a list of all of the upcoming webinars and trainings that will be available to you and other professionals in child welfare. And we really encourage you to take advantage of attending these trainings and sending them to your colleagues as well, to understand what trainings are going to be available. So I'm not going to read all of these to you because you signed up for this webinar. So you found our website, which has all of the registration links for these upcoming webinars. I will point out that our very next webinar is going to be on the juvenile treatment screening team process and documentation, and then the Qrtp assessment process, qualified individual requirements and documentation. That training on August 17th is going to go into much further detail than we had touched on today with Deb's presentation. Okay, and I'm going to turn the next couple slides here over to Eric Kratt to talk about.
Hey guys, so as Ashley indicated, there's a lot of information being thrown at you today. So we wanted to provide individuals with an opportunity to both review these webinars as well as provide opportunity for individuals who aren't able to attend to also review these webinars. So the screenshot that you see on this slide represents the place where you're going to find the recorded webinars. And that's going to be on the Minnesota Child Welfare Training Academy's website. And the website is linked on this presentation. And throughout the chat this afternoon, the links have been placed for this particular presentation, which we will try to do in future follow-up presentations. But resources and also the recordings of these webinars will be listed under the MinnesotaChildWelfareTraining.com. And then under this more option. And then when you select more, you should see SIS training unit, foster parent college, listening sessions, and then finally Family First Prevention Services Act. Some of the resources that are placed on that site right now are links to the Minnesota Department of Human Services County Link site, a practitioner's guide to the Family First Prevention Services Act, which will take about an hour, and then Family First Prevention Services online training offered through the Colorado Department of Human Services, but pretty consistent information there. There's also a link on this page right now to register for upcoming policy webinars as well as follow-up SSIS coffee talks. You can feel free to go to the next slide. And I'll put some links in the chat for some of these websites so that you can keep them and save them to your favorites. So another issue that has come to pass during webinar training is proof of attendance. So often people across agencies would like to provide proof to their supervisors or proof to their licensing boards that they've attended training for a year. So the Minnesota Child Welfare Training Academy, in partnership with the Department of Human Services, has come up with a Google form to allow individuals to register their attendance for these webinars. When they submit this form, they're going to get a return receipt that indicates which training they attended. So we're putting the onus on the individuals attending the training a little bit to keep their files stocked with those receipts. But this is kind of the alternative that we've come up with in place of sending individual CEUs out after each training session or webinar. I think that's it for me. And again, I'll post the links into the chat for you all.
Thank you, Eric. So the final two slides here, the first one is a list of federal resources for your information and viewing pleasure. So these are program instructions and information memorandums that are specifically about Family First and implementation and requirements. And if you do take the time to read them, I think that you will see that our statute and provisions that we've put into place here in Minnesota are pretty identical to the requirements by the federal government. But these are resources for you. And then as far as Minnesota specific resources, we have here a list of bulletins and publications that we have published to date. There will be many, many, many more bulletins and practice guides and policy guidance documents that will be issued in the coming months. The first one I want to point out is our County Link website. And this, even though it's called County Link, everybody is able to access it. All members of the public are able to access it, and as well as all of our bulletins and practice guides. They are either on eDocs or they are listed on our bulletins page. But these links that are in the PDF that has been posted a few times in the chat here bring you directly to those pages so that you can download them. All right, so now I am going to turn the mic over to Nick, and he is going to start reading some of your questions off, and we will work on answering as many of them as we can.
All right, thank you, Ashley. So I've combined both the Q&A and the chat for questions. I'm going to do my best to combine questions as I can. And I think the first question is going to be for Deb Beske Brown. First question, combined question is, does Ffpsa apply to short-term emergency crisis shelter programs, shelter foster homes, and child crisis respite settings?
Thank you, Nick. I think the first distinction I want to make in that list is what is licensed as a family foster home and what is a shift staff foster residence setting or group residential setting. That is a distinction we first need to pay attention to. There may be some shelter programs that your county uses that are actually family foster homes, and these elements would not apply to that. What they will apply to is any shift staff group residential facilities, and there is a shelter certification for that. I did mention that actually Title 4E allows for 14 days of federal participation for group residential facilities. And that would be especially true for our shelter facilities. So if there's a Title IV eligible child that goes into a group residential or foster residential setting that provides shelter services, that could provide federal participation for the first 14 days, but it will not extend past 14 days unless that facility has one of the specialized settings or is a Qrtp. I
Okay.
think that covers that question.
Thank you. Next question for you also is, so if the placement location begins after September 1st, then FFPSA applies, the continuous placement does not have to end and a new one have to open, correct?
That is correct. This applies to any child who moves from during a continuous placement and moves after September 30th to a residential facility, or any new placement or new continuous placement that's open September 30th and on.
Okay, thank you. Is there a rate system set up for foster residence settings related to the child's needs? Maybe the cans?
Thank you, Nick. As I mentioned, the rate that was established in the 2021 legislative proposal sets the group residential rate as the basic rate. There is no increase for, there is no Ffpsa or increase for that beyond the group residential. Beyond the basic rate that's set by the North Star, even though they're no longer North Star facilities.
Okay, thank you. I think this next one might be for Amber Buckner, but I'm not positive on that. Can I ask you to revisit what you said about payment to corporate child foster settings, that the payment is the basic or level B of the Ffpsa, that we don't do the Ffpsa?
Nick, I'll take that one. Yes, do not do the Ffpsa is no longer done for foster residents or corporate foster care. The Ffpsa does not apply.
Okay, thank you. Question possibly for Eric. So there will be a new drop-down choices for placement screens to break this all out.
Yes, there will be new placement setting and reason codes that we'll cover in future webinars.
All right,
On the
thank you.
placement, yeah, on the placement location and absence screen. Yeah.
All right, thank you, Eric. Next question, probably again for Deb. Confused about the 14 days after in one of these types of facilities after October 1st. Thought anyone placed previously that nothing would change. So does that mean no Title IV claiming after October 14th for legacy kids? So if we are able to collect North Star then?
Yeah, it's confusing. I'll totally agree. So I'll start again and maybe I'll say it better. So for children who are in continuous placements, who remain in that continuous placement, they do not move, nothing changes. They are considered legacy. But if a child in a continuous placement that was open prior to the end of September 30th, if that child moves from one setting to another, and the child moves into a residential facility, a shift staff facility, a foster residence setting, or any other shift staff facility, it would apply. So it is, the child remains legacy as long as their placement is stable and they're in that foster residence setting. Then Title IV applies. But once the child moves from one setting to another, that the legacy would end. This is similar to what we did with North Star Care. In North Star Care, we said that the legacy payment applied as long as the child didn't leave that setting. This is the same policy. Hopefully
Okay,
that
thank you.
helped.
Yes, thank you. There was several questions around this, and I'm going to have Ashley queue up slide 26 and 27. They're asking if there's a place to see a list of providers who have been certified, and this would be where you could find that once they're certified. So slides 26 and 27 should cover that. And this is public. And then Ashley, I'm going to have you go to slide 30. And Tamara, the next couple questions are going to be for you, please. On slide 30, the certification process. Just wait, I'm sorry. Oh, slide 30, reference to September 2020. Is that a typo or are we going back a year from now?
That is not a typo. So this has been a requirement since last September to document pregnant and parenting youth. So any continuous placement on or after September 1 of 2020 of last year, and the young person is 10 or older, it needs to have an expectant and parenting youth screen completed. You will begin to get AFGARS errors if this is not completed. And there needs to be a last review date in the last 6 months. So I don't know, it depends on who's handling those errors and such at the agencies. The new piece is that I mentioned, not to be confused with what was happening last year. So last year, we started documenting pregnant females, parenting mothers, and parenting fathers. The new requirement that will be released in the new SSIS release is also documenting expecting fathers. And so we will start that 9/1 or 10/1/2020. I'm sorry, I'm confusing you all. We'll start that 10/1/2021. So we'll start documenting those expecting fathers as well this year, come October.
All right, thank you, Tamara.
Mm-hmm.
Next question for you. Are there already programs that are serving pregnant youth in Minnesota?
Yeah, there are programs that are already serving this population, but as we've stated, they in order to receive payments beyond the 14 days, they will need to be Title IV-E approved, and they will also need to obtain the new certification and license in order to be one of these specialized settings. So, I mean, there's some programs like, I can't think of the name off the top of my head, but like At the Bridge, or there's also like Life Haven through Lutheran Social Services. If those programs wanted to become 4E facilities and be certified, they would need to follow this process.
Sorry, I was muted. Thank you, Tamara. One more question for you. If you want to go to slide 33, Ashley, I believe it was in reference to this slide. They're asking, what about safe sleep?
So I'm guessing you want to know what the requirements are. So in all certified pregnant and parenting youth settings, it is required that the program provides education about safe sleep arrangements to the young person. And that has to happen before the young person's child comes to the facility. And so they will need to learn the newest and safest methods of safe sleeping arrangements. I do have a small list of resources, not all inclusive, but the most accurate to assist with providing that correct information. I'll be providing that at the webinar in September, and it will also be listed in the Expectant and Parenting Youth in Foster Care Practice Guide. So we will provide some guidance around that. So, but basically, we're wanting to follow those basic criteria that is usually given through like Mayo Clinic. Maybe I'm trying to think if the U of M Health has some safe sleep information. I'm trying to think about who's on that actual list, but that list and those requirements will be provided.
All right, thank you, Tamara. This is for anyone, but I'm guessing Deb will probably try to answer this. Can you give us a sense of how many agencies will be certified and how many beds will be available for the certifications we talked about today?
Thanks, Nick. I just want to go back to the what agencies will be eligible for Title IV-E approval, or what facilities will be eligible for Title IV-E approval. And that is any agency that has one of the specialized certifications or has a certification for the QRTP. If a facility does not have one of those certifications, then the agency is not Title IV-E eligible, and the facility is not Title IV-E eligible, and therefore Title IV-E claiming cannot occur. Now, I talked about 14 days, and that's confused some folks. 14 days is for the facilities who are not certified. You do not need to have one of the Ffpsa certifications in order for the county or tribal agency to claim Title IV-E for up to 14 days of placement in that residential facility. I hope that helped.
And I'm just going to ask a follow-up question too to that, because that was asked a couple times in the chat. So even if a QRTP is certified, they can claim more than 14 days after they're certified, correct?
Yeah, so this is tricky. You can only claim past 14 days for those facilities that have one of the Ffpsa certifications, which is on screen right now. Thank you. If the facility, if you place a child in a QRTP in prior to that facility becoming a QRTP setting, and you didn't do all the other eligibility pieces prior to that, that is not going to be a Title IV-E eligible placement as well, because all of the specific details regarding the QRTP process, admittance process with the assessment by the qualified individual must occur for that to be a Title IV-E, for your agency to have Title IV-E participation in that placement. So if the certification happens after that placement for QRTP and the process wasn't followed, that will still not be a Title IV-E eligible placement.
Okay,
I'm sure I made that even more complicated. So more on that later. We'll have more on claiming with the QRTP settings. But just know that these are the settings that you can claim past 14 days of placement, or eligible to claim for eligible children. All the other eligibility criteria must apply.
Okay. Would there be an incentive for a corporate foster care program to get certified?
This is where this partnership between the facilities and the counties and the tribal agencies is really important. The department has started to have webinars with facilities in January. And I really encourage now for county agencies to be reaching out to the agencies that you are, facilities that you place with, or facilities that you anticipate placing with, and finding out and talking with them about what their plans are for the Ffpsa certifications. If the state, and keep in mind that a facility can have more than one of these certifications. They can be certified as a QRTP and a PPY. I mean, they could do that if they wanted to meet different populations' needs. That partnership is going to be important because you are the facility that makes placements in those. You are the ones that make the referrals for the placements in those facilities. And we've been encouraging the residential facilities to have conversations with the counties about what their needs are and how they can possibly look at meeting your needs with these certifications.
Okay. Another question is, will Ffpsa requirements result in a loss of short-term beds and an overload of hard-to-find QRTP beds?
This is a graduated process. So all facilities that are going to be QRTPs will not be QRTPs come September 30th. We expect facilities to come on board throughout the next year. and probably in the years to come. So working together to determine what your agency's needs are and with the facilities you place with becomes very important. It also will become very important for your agencies to also work to recruit and find foster homes and to provide supports to those foster homes for those children who may be able to be served in the community in foster care placements. I really want to mention the family and permanency team and how that also is a support for wraparound services and how wraparound services are used in your agency. So those conversations are going to be individual about the individual needs of the child, but also considering how you can recruit family foster homes to increase your pool of family foster homes that are available to meet the needs of children who may be able to be served in a family foster home with in-home services available, such as the intensive foster care services that are available through the behavioral health program and as an MA service.
All right, thank you, Deb. I have a couple of questions that I would normally ask Tendai, but Tendai is not on this call today. And so whoever would like to respond to these, please feel free. In order for a child to enter residential treatment, we already have to have a mental health professional's recommendation and a CASI score of 5. What is the purpose of having an additional requirement done, meaning CANS? And go, whoever wants to answer it.
So I will respond to that one as well. We will be covering this more in the QRTP and qualified individual training that we're providing in a couple of weeks. What I will say is that there is a statute provision that talks about not overlapping both of these processes, and more information will be provided for that as well.
Okay, thank you, Deb. We've also had quite a few questions about the qualified individual. Normally, again, I would ask Tendai for this, but if someone wants to answer this as well. Are counties responsible for finding their own qualified individual? And then will the qualified individual be employed through DHS or a mental health agency?
I'm also going to, this is a long, detailed information, and I'm also going to say that in the qualified individual training, we'll go into the details about this. We are encouraging counties and tribes to consider identifying individuals that they believe would be excellent qualified individuals to serve the population in their local area. I will also say that, as with other services, counties and tribes contract for those services and pay and determine how to pay for those services. But I will also add that the department is working on developing a program, a qualified individual program as well, where we will be identifying qualified individuals and have a means of paying for some of these assessments as well. So more information will be provided on that in 2 weeks, and then we'll also continue to provide information about this. But I do encourage agencies to start to identify mental health practitioners, but it does not require it to be a mental health practitioner. It can also be someone who's been trained. So if you want to identify community members who you believe have the knowledge and skills to do this type of assessment with family members and with engaging family members, that they could also be referred to the qualified individual training. The County Link website has a specific email designated for qualified individuals, and you can refer those people on that using that email address. You can refer those people to us, and we will follow up with them and invite them to the meeting, and also work with them to be part of the qualified individual program.
All right, thank you, Deb. Full disclosure, 2 hours is getting a little bit long for my ADHD brain, so I'm going to try to not answer the same questions, but this might be a repeat. How would the QRTP process look for voluntary placements, given the requirement for court review within 60 days? Does this apply to ED and DD type placements as well?
The short answer is it applies to any time we've considered something a foster placement. As I talked about in the beginning, when the agency has placement responsibility, either through a court order or they intend or have signed a voluntary placement agreement, this process would apply.
Okay, thank you, Deb. Next question I'll take actually is DHS aware of the acronym SILS, the Supervised Independent Living Settings Services used by DD case managers? Yes, we are. We understand that there's a few different acronyms that could potentially mean the same thing. We're trying to distinguish the differences in what all of those SILS services mean. So we are aware that there are multiple definitions of SILS. Okay. Next question. What about DD kids that have too low of IQ to be at residential treatment and are too behavioral for family foster homes? Can they still access corporate foster care?
So so this is Deb, and I will just say that this doesn't change your placement decisions and how you go about making a placement decision regarding that. Some foster resident settings or corporate foster care can become QRTPs. And if your agency is looking at placing a child in a corporate foster home, having that conversation with the corporate foster home about if they are going to be a QRTP or that your agency would like them to become a QRTP, those conversations should happen. The process I laid out for QRTP assessment by the qualified individual only applies when that setting is a QRTP.
All right, thank you. And then the last question that I'm going to ask, and then someone can wrap us up. Can corporate foster care homes opt out of Ffpsa?
So again, it's the partnership between the county and the corporate foster homes that you're using to talk about what your agency's needs are. The facility will need to make their decisions about if they pursue a certification, one of the Ffpsa certifications. Just like now, there is no requirement for a facility to become a Title IV-E approved facility. And counties and tribes place children now in facilities that are not Title IV-E approved. The certification is a new level of requirement for that Title IV-E approval. And therefore, we really encourage that discussion between counties and facilities about the needs and about what the agency needs as well as what the facility's plans are. I just tried as a wrap up, and it didn't work, to put in a link for the, we have developed a Gov delivery system to send out updates that we anticipate sending regularly, like several times a month as we build up to implementation. And I tried to send it into the link, but it did not work for the link, but there is an email that you can subscribe to. And I do believe that's on our county link website. And I'm hoping that folks can take a look at that. That was not part of our presentation. And I just want to encourage people to sign up for that because you'll get information regularly about what's new. And given that it just turned 3 o'clock by my computer, I just want to thank all of you for attending this. This was a lot of information. And so many of you stuck through it all the way through. I know we've provided a large overview of information for you. And I really want to express my thank you and to attend the other sessions to sort of understand this. And I'll turn it over to Tamara and Eric for further thank yous.
Okay, I'll go ahead. Just a reminder that there are several webinars set up in the near future. These have been marketed through the previous SSIS update, as well as our Training Academy listserv. And the registrations are also linked on the Ffpsa County Link site. So visit those sites to register for additional webinars. Following some of the policy webinars, we're going to invite mentors and other SSIS users to visit what we call an SSIS coffee talk, where we will we'll host demonstrations of the operations within the new screens that are being added to record all of this information in our social service information system. So Tamara, did you want to wrap us up?
Well, sure. I mean, I wasn't intending to, but thank you all for attending. Like we've mentioned, please sign up for the additional webinars and feel free to reach out to the individual policy specialists about the particular topics. See you all in the near future. Bye.
Thank you.